This is a divorce. It is not good on either side.
She is mean and she's obsessed with harming me.
All you have done throughout this sham of a marriage is lie.
Mr. Johnson had a choice. We wouldn't be here today had he done that. I started receiving text messages at midnight, at 12:30 in the morning.
I'll start by, I don't want to get too much into this because I do anticipate Ms. Johnson's going to be speaking, and many of the things that the city would say would be encompassed by her recommendation. However, we do maintain our own recommendation, which may be independent from hers. Your Honor presided over this trial. In this situation, the city feels that the 10 days is appropriate. Although it may seem like a small or de minimis violation in a vacuum, the broader context from the city's perspective is particularly relevant in the city's recommendation. Ms. Johnson has prepared a statement, as I said, and she'll go into greater detail about why it's appropriate, but the city wants to make it very clear that this was not, from its perspective, an innocent or unknowing violation, nor was it a one-off event. At the time of this incident, the order had been in effect for less than 14 months. As the court sees, we're addressing 3 SOCs for 3 violations of this same order in that short amount of time. Finally, the city would like to remind the court that this is the exact hypothetical scenario that's frequently mentioned when parties have no contact orders entered. That is, if you happen upon a protected party at a grocery store, it's your duty to immediately leave. That is, from the city's perspective, exactly what happened here. And as the conviction reflects, Mr. Johnson did not do that. And the city maintains that its recommended sentence fairly balances all the facts and circumstances. Thank you.
So did you want me to hear from Ms. Johnson?
Yes, please.
All right, Ms. Johnson, would you mind coming up to the table there next to Mr. Fortunato?
Okay. My statement will be sort of brief because I've expended more time on you throughout all of this than you deserve. Let's start with what got us here. Obviously, you're cheating. You became merely a paycheck. I trusted you in my house with my daughter and myself, and you failed both of us. And now you're back to step 1 in your life. You struggled to stay relevant in your retirement, and I think that was a lot of the problem. All you have done throughout this sham of a marriage is lie. You thought the law didn't apply to you regarding the protection order. The law told you different. Lastly, the one thing that I can never forget is when I finally begrudgingly agreed to have relations with you only because I was scared you would escalate in your anger. Then you left me on the floor to recover from your assault. You came into the room later to check on me. You barely opened the door. You asked if I was okay. I told you no. I couldn't even get up off the floor at that point. You really shut the door after that. Later on, after I was able to stand, I locked the bedroom door to keep you out for fear of my own safety. You took a screwdriver and popped the lock to get in. I was terrified. It was your attempt to try to control me and scare me. You told the presiding judge for the protection order that, well, nothing scares Erica Ann because she was a police officer. Well, under the excuse that I'm law enforcement, you said I'm fearless. Behind closed doors with an intimate partner is totally different. Big difference. You have no capacity for feeling empathy, true love, and trust. My recommendation for you, which is much earned in my opinion, and this is just a recommendation, Your Honor. 1, a mental health evaluation. 2, a domestic violence evaluation and treatment. As for jail time, I would like to see 30 days per conviction running concurrently with two months of that suspended for the 5 years. And this is not because I want to give you any leniency, but assure me that when you violate again, this will be hanging over you as a hopeful deterrent for your own sense of entitlement, and because I know you will violate because you are a malignant narcissist in my eyes. We will be back here. This is in no way my feeling sorry for you. This has everything to do with my personal safety, as well as that of my daughter, and stop texting her. I could have asked for the max jail time for you. Just remember, the law protects me, not you, under this protection order. I never want you infecting my life again. Stay out of my life. Stay away from me. You don't deserve any leniency from me on your sentencing, as well as the prosecutor's recommendation. You need help. Thank you, Your Honor. Thank you.
Thank you. Mr. Johnson is 72 years old. He'll be 73 years old this October. For 37 years, he worked for Cairo News as a news producer. Never had any problems with the law in his life, ever. When he retired, Governor Inslee personally wrote him a letter. He is mild-mannered, law-abiding, and he's never had a problem with anybody in his whole life. He comes to the end of his marriage. Divorces, breakups, they're never amicable. They're fraught with tension. They're fraught with emotion. A lot of things are said and done over a lot of these type situations, and we've been doing this. We've seen it all. Erica Johnson is very aggressive, and I know that during the course of the no contact order, Mr. Johnson denies all the underlying things that she just said. He's denied them consistently. There was never any police charges filed, never any police reports, never any photographs. Despite being law enforcement, she never took a single photograph, never filed a single police report, nothing. There was never any criminal charges resulting from any of that. There was a domestic violence protection order. Mr. Johnson represented himself at that hearing. He thought he'd just tell what happened and tell his side of it, and there would be no order. He was wrong. The order ensued. Erica Johnson, again, is very aggressive. She kept after him with phone calls, text messages, emails, a barrage of things kept coming at him. He responded with an email, not threatening, just what we would normal communications. He responded with a text message, and he responded with communication through a third party to their daughter. None of those were threatening. None of them were meant to be. They were normal day-to-day communications. However, they violated the no contact order. We resolved that by entering into stipulated orders of continuance. He went to do the evaluation because there were 3 of them. He was set at the highest level of treatment. He's been in treatment now and been in full compliance with it. He makes all of his meetings, does everything he's supposed to do. The order was renewed in January of this year. I represented him on that. The judge renewed the order, which is not uncommon. And very shortly after that, I think the next day actually, or within a couple of days, Mr. Johnson went to Costco. He's with Judith Saxton, and the court heard how the evidence came in at the trial. Mr. Johnson did not plan on seeing Erica Johnson there, did not plan on seeing her car, did not plan on seeing Molly. He pulled it back into a parking spot. He got out and he saw her car. At the time, he didn't see Erica Johnson, though. She was in the car. He didn't see her. And at the time, he wasn't really thinking about, I mean, he knew, I think, at some level that he couldn't be within 1,000 feet of the car. But that wasn't what was on his mind. What was on his mind was running into Erica. He didn't want to do that. And him and Judith stood at the back. They were there 10 to 15 seconds and decided what to do. Now, the law says that if you accidentally come in contact, you have to immediately withdraw and remove yourself. Mr. Johnson had a choice. He could have gotten back in his vehicle and driven away. We wouldn't be here today had he done that. What he did instead was went into the Costco, thinking that that would be withdrawing from the situation. I think it's fair to say that he did not intend to commit a crime. He did not want to commit a crime. In fact, he tried not to commit a crime. However, the walls of the Costco are such that he could not get 1,000 feet away. He was confined by Costco. If the store had been bigger, he would have been 1,000 feet away, and well, might have still been here, but he would have been, I think, outside the 1,000 feet. He didn't intend to commit a crime, but nonetheless, I mean, there's actus reus and there's mens rea, and here there's actus reus. He didn't get 1,000 feet away. And I think when it comes down to, we didn't get a chance to talk to the jury afterwards, but I think it's fair to say that what the jury saw was that he did not use ordinary care and caution. I think that's the legal standard for negligence. And I think that would fairly describe what happened in this case. He was faced with a choice. He chose wrong. You know, he did, but again, he was kind of panicked at the time too. What do I do? And he made a decision to do that. He did not contact Erica Johnson. He did not attempt to contact her and would not have. He would have ran away, to be honest with you. He's a very mild-mannered person, not confrontational at all. But he made the wrong decision. And I am 100% certain that if this situation were to repeat itself, if he were to come into contact with her vehicle in a parking lot again, he would get in his car and he would leave. As it is, you know, besides the domestic violence treatment, he has been undergoing tremendous anxiety. He's on medication now. He never goes anywhere without having somebody with him in case there is some sort of cross paths with Erica Johnson. He's afraid of what she might do. And in fact, at one point, while this case was developing, she started sending him emails and text messages very aggressively. I texted her, I said, please do not contact my client. I started receiving text messages at midnight, at 12:30 in the morning that start off, hey, tough guy. This is the personality he's dealing with. He himself is very mild-mannered. He responded incorrectly on the 3 violations of no contact order and SOC. That's why they were SOCs. And in this case, he made the wrong choice. To do over again, I'm 100% certain that he would get back in his car and leave. And he is in treatment. He's doing what he's supposed to do. While, again, I appreciate Erica Johnson's, she's going through it too. This is a divorce. It is not good on either side. It's emotionally charged. He's very close with Molly, who is just her biological daughter. He's tried to maintain at least some sort of, you know, friendship there. He's with her since she was 11 years old. She's now in her, I think she's 26 years old now. And so it's very hard on all concerned here. And it's a family law dispute that's being handled with attorneys. My recommendation to the court is that the court not impose any jail time in this. The court, having the 3 SOCs revoked, he now has 4 violations of the no contact order on his record. This is a guy who went 73 years as an upstanding pillar of his community with a letter from the governor when he retired. And he now has 4 criminal convictions. He is being medicated for anxiety. He's had a lot of problems this morning, physical problems as a result from all of this, the stress and the anxiety that he's going through. He will continue on with his treatment. I think suspending any jail time in this case is appropriate. The other thing that's hanging out there is now with 4 convictions on his record. If he was to violate again, it would be a felony offense. And that's one of the reasons we didn't take a plea on this, is what was offered up would have put him in a position where if he did have accidental contact and he did do it wrong, he's faced with a felony prosecution. If you take 4 criminal convictions, we look at the principles of punishment. General deterrence, specific deterrence are accomplished here. He's not going to offend again. As far as rehabilitation, he's in treatment. As far as labeling, he's labeled, and if he offends again, it will be a felony prosecution. The only thing left on that list is retribution. And in this case, and sometimes it's appropriate. Sometimes we need to step up and smack somebody, but this is not that case. Mr. Johnson has so many good things that he's done in his life, and so many good things we can say about him, that letting the angst and anger and emotions that fly high in a divorce, especially when there's these kinds of allegations being thrown around. It's very stressful. And I think that he has been punished a lot already, having to go through this process, having to hire a lawyer, having to go through a jury trial, everything that he has gone through thus far. I don't think there's anything more we could do to him. Putting him in jail would be a catastrophe in his life. And I don't think it serves the ends of justice under these particular facts in this specific case, Your Honor. Thank you.
All of my affairs, they're all imaginary. Erica has got it in her head that I have this harem. She has accused me of sex with our neighbors, sex with old friends, new friends, my coworkers, my healthcare providers. She even accused me of an affair with her older sister. In November of 2023, she went to court and swore under oath that I was evicted from my home. There was never any violence in our home, none whatsoever. Again, I held her down, and that never happened. I respect her career as a law enforcement officer. I know that she's tough as nails. I told Mr. Bernberg, if I had ever done any of these things that she claimed, I would have left the house that day, either in handcuffs or a body bag. She continues to tell anybody who'll listen that I'm a monster, and I'm not. She's accused me many times of being on the autism spectrum because I'm so low-key and unflappable. We never had any yelling, screaming, hitting, punching, slapping, kicking cans, slamming doors in our home. It never happened. I was totally blindsided by that protection order. It was a typical morning. I woke up early, made sure Eric was up, took the dogs out, brewed a couple of lattes, wished her a good day. She drove off without a word. 10 minutes later, 2 sheriff's deputies came to the door. I invited them in and said, guys, hey, law enforcement's always welcome in this house. And they handed me this stack of papers. And as I read it, I was incredulous. I couldn't believe what she was saying about me. And I now know this was all about the affairs. Infidelity is not a crime. It's improper, but it's not illegal. So she fabricated domestic violence, and she continues to try to harm me. 4 days after I was evicted, she closed her bank account, took $4,000. I was penniless, no cash, and all of my retirement benefits are direct deposited into a bank account that no longer existed. I spent days on the phone for hours at a time trying to convince Social Security and 3 pension plans that I am who I say I am, and please move my direct deposit to a new account. But she wasn't done. I was paying the Verizon cell phone bill for Erica, Molly, and myself. One day my phone stopped working. I logged onto the account. She'd gotten into the account and dropped me. What that did was it blew up my phone number, a number I had had for 3 decades. It was my work phone. And when I retired after 37 years, Cairo TV gave me the phone and the number. When she blew up my account, that number was gone forever. It had sentimental value. As for that letter to me from Governor Inslee, which he had hand delivered, she wadded that up and threw it away. Molly found it in the garage and brought it to me. And then my healthcare providers told me that my insurance was being kicked back. I contacted Regents. She had dropped me from health coverage. I pay the insurance on the house and 3 cars for Erica, Molly, and I. Erica clumsily tried to get into that account. It's password protected with my face recognition. But I could see exactly what she was trying to do. She was going to get in there, drop me from coverage, and I'd be driving around blissfully unaware that I was an uninsured motorist. This is what she does, Your Honor. She is mean, and she's obsessed with harming me. I have done nothing to hurt her. I have never attacked her. I do not harass her, but she has been doing everything she can to turn my life upside down and inside out, and she's obsessed with it. When she says we'll be back here again, oh God, yes. If she sees my car, she'll call 911 again. In this incident that brought us here, she She claims that I was right next to her car glaring at her menacingly. That did not happen. Judy Saxon and I were 50 feet away. And we walked away, and Mr. Bernberg and I actually used one of those public works devices, the measuring wheel. We traced our steps. We went 828 feet from Erica's car. It wasn't 1,000 feet, but that's how much I was trying to get away from her. And at the same time, Erica and Molly drove away 15 miles to Steamboat Island. There was no violation there. We were not trying to hurt Erica. But at the same time, she did not call 911 then. She went home and did what Erica does on a Saturday. She started drinking. 6 hours later, she called 911. I've got a copy of her statement to Tumwater PD sent after 11 p.m. We're talking about 8 hours of drinking. It is a rant. It's not a report. It's full of disjointed sentences and punctuation errors and falsehood after falsehood after falsehood. She just keeps trying to hurt me, Your Honor. I just want to be left alone. You're probably wondering why we're still married. I did file for dissolution and I hired an attorney. We put forward a fair and equitable settlement. We take what we brought in. I take my stuff, she takes her stuff, we divide the other stuff down the middle. Erica is representing herself, and Erica's view of a fair and equitable settlement is that Erica gets everything. So we are at a standstill. So, Your Honor, I'm asking for leniency for two reasons. The first is that I'm not a monster. I never was, and I never will be. I will never be a threat to Erica. For all she's done, I still love my wife. But secondly, and more importantly, I'm hoping leniency sends a message to Erica to stop trying to con this court, lie to this court, and use this court as a weapon against me. As Mr. Bernberg pointed out in his closing statement at trial, a protection order is supposed to be a shield, not a sword. Erica has weaponized it. She is going after me with everything she can, and she's trying to ruin my life. The health problems I've had have been considerable. I've never had a panic attack before 2023. They're all the time now, Your Honor. They don't ever stop. It was very difficult for me to be in court the last time. It's been difficult today. As you recall, Mr. Bernberg asked for a brief recess to confer with his client just before my testimony. He was getting me out of court so I could run into the men's room and dry heave for 5 minutes. I couldn't come into the court this morning for about a half hour. Another attorney saw my distress and sat me down outside, and I waited for Jay to arrive. I was just having a terrible time again with panic. It's very difficult to be here and address you. But Erica is suffering from some real problems of her own. She's been in some sort of mental health crisis. You remember when she was a police officer? She is no longer a police officer. Her career was terminated because of her behavior. And she has been going sideways ever since. I wanted to get help. She accuses me of having a mental health problem. No, Erica was terminated from her job, then attempted suicide. I am convinced she has a very serious mental health problem and it needs to be addressed, but she refuses to have anything done. She claims she doesn't have a problem. Everyone else has a problem. So, Your Honor, in closing, I'm a good person. I've just been portrayed as a monster. I am not a monster. Never was, never will be. Begging this court for understanding and for leniency. Thank you.
Well, a lot of what I heard really does go beyond the scope of the criminal trials, and I can't make any conclusions or any findings on those other contested matters. There haven't been hearings. This court doesn't have jurisdiction over those issues. I appreciate that they've been provided to give the court context about the nature of the relationship and maybe what led everybody here, but they simply can't take either version of this at face value. I don't have the ability to do that in this context. What I can do is essentially narrow that focus. And in this case, in these cases, the focus is on the no contact order, the protection order that was issued by the Superior Court, its terms and conditions, whether it was violated, context in which the violations occurred. And, Mr. Berneberg has pointed out numerous times that the alleged violations in each of the particular matters are relatively minor. They're not what he's, I guess, characterizing as aggressive violations. And I would agree with that. And of course, I heard all the facts that were brought out during the trial and very familiar with the violation that was the subject of that trial. So the point is that the order that was issued by the Superior Court does have to be complied with. Now, the background information about how it ended up being issued, the background information that was provided by the parties, whether it was true or not, it was evaluated by the judge in the context of that hearing. The order was issued. That order has to be complied with. And that's what brought us here. And I can't and won't dismiss as meaningless the violations that did occur. Even if those violations didn't in and of themselves involve acts of violence or acts of threats of violence or anything like that. So the violations are meaningful. They're also mitigated by some circumstances that have been brought up here, including the fact that Mr. Johnson doesn't have any criminal history at all before these issues were brought up. Mr. Johnson's age, he's lived a long life. He's been a contributing member of the community without accumulating violations. So, that certainly isn't ignored any more than the reverse is ignored by the court. I do have a concern or two in regard to this, though. I'm concerned, Mr. Johnson, that you don't take the provisions of the order seriously, not to the degree to which the judge who issued the order meant them to be taken. An accumulation of small offenses can be an indication in and of itself. And in this case, I think that may very well be. One thing that Mr. Fortunato said during the trial that stuck with me even to this point is that there's another Costco in this community, and the solution to your problem was obvious, but you didn't take it. And in my view, maybe the reason you didn't take it is that you didn't want to have to comply with the conditions of that protection.
I would disagree on it.
It happens. No case is exactly like another case, but there is an accumulation of my experience dealing with people who do commit crimes or violations in the domestic violence world. And one of those is control. One is to show people, including judges, that you're not going to be controlled. And another is to show protected people or victims that you're not going to be controlled by anyone and that their lives at your mercy. Now, some of the patterns I see here kind of resemble that. But on the other hand, like I said, I'm balancing that with the other things that I've heard here, particularly from Mr. Berneberg, who's always represented, I think, very well your position to the court. Now, what I mean to say, Mr. Johnson, is I don't think that you're a monster who needs to be locked up. And if I thought that, I would do that. And the tools are available to me right now to do that. But I also think that you're somebody who has not, to this point, taken the order that you're under the restrictions of entirely seriously. And there are certainly ways to avoid, really easy ways to avoid violating a no contact order. These violations did not occur because Mrs. Johnson set you up for them. These violations occurred because you did them, and you did them intentionally. And that has to stop. And Mr. Berneberg said it. If it happens again, it's a felony. They take your prior misdemeanors into account when felony sentencing for crimes like this too. I didn't do the math, but I'm sure that Mr. Berneberg did and can tell you with great certainty what kind of a sentence you might be looking at if this were to happen again. And that would be a very different kind of proceeding. I'm going to impose 364 days and suspend all 364 days. Suspend that for the next 60 months. Conditions of the suspended sentence are to not violate the law, not possess any firearms or other dangerous weapons, and comply with the protection order. I did review all of the police reports that had been submitted in issuing a no contact order. I know there's an order of protection out of the Superior Court, but this order is going to be in effect for the next 60 months rather than that order. Well, in addition to that order, which is only in effect until January of 2026. All right, Mr. Johnson, do you have any questions for the court about your sentences?
No, Your Honor.
Okay.
If you're involved in a dispute with another party such as this and you just can't seem to work it out, don't resort to taking the law into your own hands.
We'll hear the litigant's reaction right after these messages.
All right, thank you very much. Officer Bell's waiting for you, and that will bring this case to a conclusion.